Here the heart will melt. Here the tide will turn. Here it all will start. And in the end, we just
A stack. I'm not going to do any direct response, so I'm going to let you know that right up front. We'll do one round. I'll take a stack, and then we're going to start with clarifying questions only. We'll do clarifying questions for a couple times, and then we'll get into the meat of discussion. So 1, 2, Joy, you're 3, so you'll be 4, 5. We'll do those 5. So, and then at the end of those 5, we'll come back and do another one. And if you've got one specifically to Dan or me, you can ask us specifically. If you have a general question, you can just throw it out. Number 1.
Okay, Dan. How would people get elected as delegates to the convention? What kind of rules would there be, and who would set those rules? And what bars to corporate, manipulation would there be, and how would that be sustained by the Supreme Court?
Well, let's first start off with delegates. There will be an election. It does break down by population, congressional districts. If you look under FEC law, the definition of election, item E says the election of delegate to a constitutional convention to propose amendments. They will be elected. During that election, there will be a time to build consensus around the various issues that they support. The rules in a convention will be created by the convention itself. Normally what you would see in a convention is that they would adopt Robert's Rule of Order.
Can I stop you there? I'm not talking about what happened in the convention. I'm talking about the election for the delegates to the election.
It is treated exactly like any other office to a federal position. Under the law, they are identical.
So therefore, the corporations can buy candidates.
It's very possible. We can't stop it.
Number 2.
Number 2, I got 2 questions, and the most important one to me is, can someone, it sounds like someone needs to sue to get clarification on these rules.
That was done. There were 2 lawsuits brought through the Ninth Circuit Court by Bill Walker and Friends of Article 5 Convention. They did take it to the Supreme Court. The Supreme Court denied certiorari. They would not get involved in political action with Congress. Therefore, Congress is in total control of the situation. And as we've seen through this letter, they have been creating an invisible barrier to these applications from states for. Actually, the Research Act looks like we were due for a convention in 1907. Not sure exactly what happened. The clock's locked. And they passed the 17th Amendment on their own, or Congress did. And it appears as though we've been due for a convention ever since. Just since in the 60s alone, during a 7-year period, there was over 160 applications that came in. And I think we would all agree that if they had counted those, and shortly after the Cuban Missile Crisis, during the awakening, I guess, that happened in the 60s, I think we would definitely be in a much different world today because of it.
Okay, my other question is pretty closely related, and that is, and I think I kind of know the answer, is specifying a single issue. It doesn't really matter, right? Whether people do that or not.
A lot of states do apply for a single issue. The clause, Article 5, does call for amendments in the plural. So it does require multiple amendments being written. There are a lot of people who believe that it needs to be the same amendment. It needs to match up between. So everybody must apply for example, the balanced budget amendment. And if they don't, they don't count. The truth is, states don't apply for an amendment. They are applying for a convention. And the delegates get to choose which amendments to propose and deliberate on. The states do not control the amendment process. It was discussed in the original convention in 1789. whether they would allow states to propose amendments. They considered it twice, they voted it down twice.
So doesn't need clarification, it's in the rules.
It's there.
I'm going to have to jump in and say that's not how I see it and how I read it, because the rules are actually, 40 words in Article 5 itself. I mean, there are opinions about what that would mean. You can read it, Margaret, if you like. It's very short, right? So there are some scholars who do agree that Dan has described what is most likely the case. There is I
would take another look at it though, because if you read that clause, it does say they will petition for a convention
correct. And
for the purpose of proposing amendments.
right, and just to put a fine point on it, if I'm understanding the second question that you're asking, there is a body of jurisprudence, or of thought amongst constitutional scholars that say it's pretty clear that you can call a constitutional convention for the narrow specific purpose. But it's not clear if that would act, if the convention delegates assembled would be bound to it or not.
Well, I think what the problem is here, and a lot of what you're talking about, is we've had so much disagreement about what counts and what doesn't. And frankly, I got tired of it. So I went to the Congress and I said, what counts? The answer was nothing, not even the rescissions. They didn't count any of the rescissions either. The state of Texas considered rescinding their application from 1899 this year, and it failed. It was an open general convention call. It's one of the, I turned in 42 states to them, asking them to verify the applications that I sent them. They were legal standing applications that in many cases would say, had language in it that included that this is a legal standing application until 2/3 of the states have called for a convention and Congress has called it to order. So these things don't have a time limit on them. They survive the people who authored them. And when Texas tries to repeal it, it's pretty obvious that it still counts. But according to Congress, none of them count. So I'm still waiting to get verification of what I sent them. And actually, let me add in here too. The problem that they have is they're telling me that they don't have any process to count these applications. And I counter them. That's not a problem. And they tell me that the process, the duty, is unassigned, and that's why they can't do it. There's no rule that tells them that they're allowed to count these things. Well,
Yeah, that catch-22, it's a good catch.
well,
that catch.
there's also this caveat in the Constitution, the 10th Amendment, that any duties unassigned are reserved to the states or to the people. And I'm a person, and so I turned it in, asking them to verify what I've already done. It was the only way to push them on this. So now they're completely lost. And they're going to refer it to the Judiciary Committee, and I'm sure it seems like a favor to me to go ahead and pass it to them. But I know this is a black hole. That is why I asked the President to oversee this. It's quite a phenomenon. And who would have figured that over 200 years would go by without them establishing rules to do this? But then what are the odds that they didn't do it in the Senate either? I sent a letter to the Senate.
So then let's try to keep the stack going. So if you want to.
Yeah, okay. But I did send a letter to the Senate. We're going to find out if they have rules either. I bet you they don't. Next question.
Number 3.
Dan, you said, if we cannot amend, we must abolish, and I couldn't hear what you said right after that.
I said I don't want to do that.
You don't want to
I do not want
abolish
to
this
abolish.
Constitution?
I do not want to abolish the United States.
Oh, you do not want to abolish the United States?
Right. It is our right to alter or to abolish. And if we cannot alter,
Oh, I thought.
we must abolish because obviously our system is broken. Boy, I really don't want to do that. I think that would cause quite a mess. And I would rather just tweak some changes, and I think we can do that. I think we have the capability. We all have opinions. We may not have consensus, but everybody's got opinions, and I think we can express them.
Number 4.
Hi, I'm unfamiliar with Article5.org. Can you tell me who Dan is, who Article 5 is, and do you advocate specific amendments?
We do not advocate specific amendments. What we're trying to do is create the opportunity for groups like Lumen, Wolfpack, other groups to go in and propose the amendments that they are working on. We're not taking any sides, and we're trying not to. We were born out of an occupied group, so many of the beliefs that we each have individually do support many amendments. Obviously, we all have some reason to be in the group. But as far as choosing our favorites, we do not. And I am Dan Marks. And articlev.org, like I said, is basically it's the legal incarnation of our Inter-Occupy Article 5 work group that we had started years ago. And it was a collection of people who were just fed up and knew that we had to do something to create a path of victory for all of us.
Number 5.
Two quick ones. First of all, it occurs to me, is a freedom of information request possible? No, not to get a hold
They're
of
exempt from
yourself.
Congress, yeah.
Okay.
Right.
And then the other thing would be, and I guess more to David, is why is it a Y in the road? Why is it not something that can be pushed on both fronts through our petition drive or whatever else? Why is there a choice to be
Well, I mean, I guess if I'm understanding how you've articulated the question, you just agreed with me that we don't have to make a choice one or the other. But
Not right now, no.
yeah, but the point is, you have to count something, right? So at some point, you have to either be like counting 2/3 of congressional votes, which at least we know that can be done, right? They've actually counted that. Or you have to be counting 2/3 of the applications for a constitutional convention from the state governments. But the point is, you could do both if you've got, I see your hand and we'll do another round. You could certainly do both, I mean, but I guess what I would say is, from our opinion at the National Leadership Team of Move to Men, we are not going to put resources into the convention process. I mean, we're not going to support it or oppose it at this point. There's nothing, we just don't see any leverage point there. That's how I would answer it. But if there's stuff popping up, I see your hand too, we'll do another quick one. Does that answer your question?
Yeah.
So let's do another one. I've got number 1. Lee, you're number 2. Let's see, anybody else? So Jim will be number 3. We'll do those 3.
Just have a direct address to the question I just asked. 4 out of the 17 amendments after the Bill of Rights used a convention campaign to leverage to get Congress to actually propose the amendment they wanted. So I think dual tracks usually arrive at the outcome we want here. And whether we get it through Congress or through the states, I think we all just want this amendment.
Oh, you want to react?
No, that's okay.
Lee.
I guess it's a related question to you, David, so, because that's what I have understood the model Minnesota bill as almost like a dual track model, and I just was hoping you'd see was I right to think of it that way, and could you describe that a little bit? And also, not to try to draw out your differences, but I would love to hear a little more as your lawyer side, what your thinking is that you can restrict a convention.
Well, I mean, I'll answer the second part first around why. I haven't actually done any of the legal research myself. I've engaged constitutional lawyers and other scholars in conversation, and I've kind of gleaned that there is an opinion out there. So I don't actually take an opinion. I don't take a position that one of the opinions is even have more merit than the other. I'm just trying to report that there is this idea that's out there. And my ambivalence is even stronger because on the one hand, I am deathly afraid of a convention that would actually propose to codify under law that marriage is only between a man and a woman, that women have no constitutional right to freedom of choice, and that once, you know, I mean, I could go down the list of the things that the horrible things that might happen. And yet, the same person can stand before you and say, oh my God, if we have a convention, we could actually codify an affirmative right to health care. We could codify an affirmative right to shelter, a right to education, and actually write into our founding law that education must be completely free through college. I mean, like, there's any number of, like, amazing things that can blow up. I will say this. It's why I keep defaulting back to, and I'll answer the second question first, and Mark, I'm going to put you on the spot that I'm going to ask for a little help in Minnesota. But the reason that we at the National Leadership Team have been consistently saying, don't get too hung up on the proceduralness of any of the things. There are a lot of folks that immediately default into that. But if we keep it at a democracy movement at this point, it actually says we are fellow travelers on the road to where we're basically all trying to go, and it keeps us, we think, sort of way more together. And this comes out of 15 years of work. It also comes out of watching what happened in the Global South. It comes out of the work of Gene Sharp, as some of you know some of that work. I mean, so my point is that the procedural stuff, including like really big stuff, we just don't think that it actually is that helpful, which is why we've been trying to be ecumenical around these two. And so that's kind of where we get to with the ecumenical approach, is whatever works, because it is kind of a hybrid. And Mark, are you up for me tossing it to you right now, or I can do the Minnesota model? But you were on the ground, brother. You like lived it. So
what David, Mark Halverson, and we'll be talking about this tomorrow at 11 o'clock. So the Minnesota model that David's referring to, we have a resolution in Minnesota that passed through our state senate and has not had a vote yet in the House. And it's moved to amend approved language. And what it's calling for is calling for a constitutional convention. If Congress doesn't enact the very first step, as David talked about, that we will go the route of a constitutional convention. We have that language in there as a prod, and as the gentleman here said, the number of amendments that have already been passed, the threat of constitutional convention has been used to get those passed. So that's the language we have in Minnesota. Again, it passed the state senate, hasn't passed the House. We're going to continue the fight next year. But the biggest pushback that we've gotten has been the Article 5 convention, and the threats, the fears of a runaway convention, and all of the things that people are talking about so far. We've been getting it from many of our state legislators. So it's a tough sell. But the other thing I want to point out, of all the 16 state resolutions that have been passed, none of them have any mention of Article 5 convention. And this is kind of a test case. That's why we're talking about it at 11 o'clock tomorrow opposite David's panel, for those who are interested in more details.
yeah, and that's at 11 a.m. Tomorrow, and it's actually called Engaging State Legislatures in Move to Amend. And as Lee, who will also be on the panel with Kaya here in Wisconsin, and along with Mark, we really are kind of calling it the Minnesota model, because it is that kind of, it is a hybrid approach which says we're giving Congress a certain amount of time, at which point then, like if the Minnesota, because this is the thing, this is legislation, not a resolution. A resolution is a statement of sentiment. Many of us have worked on them. They're good organizing tools. They have zero legal effect. Minnesota would actually have legally binding effect, because it would give a time period by which Congress either sends the We the People amendment to the states for ratification, or count it. And that gets us into this other problem. So I'll go, you're already on the stack, so.
I would like to respond to that too, real quick. There is no power that a convention has that Congress doesn't already have. If Congress can pass any amendment it wants, Congress is already full of people that are controlled by lobbyists. There's absolutely nothing that's different, really, about this situation. They propose amendments and they vote on them. That's it. When they were getting rid of prohibition, it's the only time that Congress opted to send the amendment out to state conventions. They have a choice to ratify amendments in a state convention or in state legislatures. The only time they ever chose to send it through a state convention was to legalize alcohol. And why? It got everybody off the hook. It took the politics out of it. Nobody was held liable for their next election. It was clean. This is an unpolluted convention. It's like if you take a contaminated jury, tampered jury, you clear the jury, you get a new jury. That's exactly what this is. It's one meeting, and then everybody goes home on a prayer.
You have number 3, and then I saw a lot of hands got provoked, so we'll do another round.
Yeah, I think I'm number 3.
You are?
And that is a perfect segue too. The Minnesota was exactly one of the 2 things I was going to ask about. It seems to me that, and you just said it, basically that the Congress route really carries no weight over time, and the Article 5 does. So I'm surprised that move to amend isn't pushing more for number 2. Though I did detect that the fact that that's a little bit harder to do, but since when do we shy away from anything hard in this group? So that's my first question. My other question is, can we sue Congress to get a clarification on the rules?
No. It's been tried, but we can't. In fact, the Department of Justice was also contacted last year by John Geis in Georgia. He filed a criminal complaint against the members of Congress for violating their oath of office and the mental reservations clause. They're not allowed to have mental reservations about this, about obeying the Constitution. And but here we are. The problem is that they've never seen it. They've never had an official tally that says we've crossed the threshold. The members of Congress are not allowed discretion when they take a look at these applications. The only question is, did state X apply or not? They're not allowed to take a look at the applications and go, well, I don't like to look at this one. They're not supposed to send it to a committee, but that's the first thing they're doing. We're getting out of the academic into the reality of this stuff now. And our forefathers had all kinds of ideas about how Congress would react when they were posed with the situation. They had not anticipated how the bureaucrats would react when they came into this situation. We're kind of a little bit discombobbled, really. We weren't expecting this, but it was confirmed in a Congressional Research Service report last year by Thomas Neale that it was time for Congress to consider the applications of the states because of so many. There's been over 700 of them. If you go to our website, articlev.org/map, you will see all 700 of them, and a map that if you mouse over the state, it'll show you what applications were made, what year, and for what amendment. Sometimes it's a general call, sometimes it's limited world government. There's all kinds of amendments, ideas out there, and it's been going on for so long, it's time for them to count.
So I guess, to the point back, you're surprised that we're, again, like, the Minnesota model actually is utilizing both. We're not prioritizing one or the other. What I have seen happen as this movement has gone forward, even over the last couple of years, is that people tend to gravitate towards one or the other. And so we say, okay, like, fine. But at the end of the day, like, Mark can tell you that even as it was sort of gaining traction, and Minnesota is far and away the furthest along that we got anywhere, right? And Minnesota, because frankly, the 16 resolutions don't mean anything. I mean, again, like, they don't have the legally binding effect. They're organizing tools, but I want to tell a quick little story of the resolution that I think is important to really get back to why we actually have to have a movement where people are engaged in a sustained struggle for power. Because I was really excited when we got a call from a city council member in Richmond, California, who wanted to help because they had heard about the resolutions that had been popping off all over the country. They had heard about Move to Amend, and I gotta say, pretty cool when elected representatives are calling you, right, to want to do it. And especially, let's just lift up that Green Party Mayor Gail McLaughlin using eminent domain to stop foreclosures. See what happens whenever you actually control the state apparatus. You can do important things, right? Point of this is, city council member calls and says, I've got the votes. The Richmond Progressive Alliance of Greens and Progressive Democrats, we run this joint. We'll get a resolution like that. I said, that's fantastic. So let me get back to you. We'll find somebody to help you walk through the language. I had to have the responsibility of calling the city council member, and I'll just say this, sir. So we'll give you a name, sir. Thank you so much for your support. It is my duty to inform you that Richmond, California has already passed the Move to Amend resolution. Sir, you voted for it. See my point here? Like, this notion, like really and truly, it's because like even for him who's doing work on a day-to-day, it was like another of those resolutions. Who heard Leland Pan last night like several of you? And again, like he said, look, I can get progressive Democrats to pass resolutions all day long on really good resolutions, right? But as soon as it actually gets down to how money is allocated and spent, as soon as it gets down to actual power issues, I lose most of them. This is a political issue that is going to require we the people to exercise coherent power. There's just no getting around it. We shouldn't be afraid of power. Because it's not power over dominator power. We're talking about power with. This is like movement power. We should embrace the fact that we're learning how to do this. And so you make the path by walking. And that's what I would say again, is like that we're making the path by walking, and we'll be figuring out things as we go along. And I want to be very honest, y'all. The National Move to Amend folks we didn't drive or dictate the Minnesota model. The Minnesotans basically came to us, partnered with, we kind of supported, let you clarify this a little bit, we worked with, and also so we were in sort of a much more collaboration. I don't feel like we dictated, except for we said you can't sell out on the issues that Move to Amend. That's the only thing. And then we said, well, what are we going to do? And we partnered with the local affiliates. Mark, you want to clarify that?
I just need to clarify that the Minnesota model is not driven from the grassroots. We had a state legislator, a senator, who came to us when control of the legislature flipped dramatically from all Republican to Democratic control. It doesn't always make that big of a difference, but it means the difference is whether or not you can discuss a resolution like this. If I had my druthers, we would have waited a few years because we're in the movement building stage. This is putting the cart in front of the horse. I was going to mention this tomorrow. So here's the thing. You don't want to let a look at the horse in the mouth. When a state senator comes with you all gung-ho, we want to push Move to Amend friendly language. We had to make a decision. We say yes or we say no. So we said yes. Whether, I don't know that the story has yet to be written because we won't know until next year whether or not it will pass. Is it too soon or not? But for the record, it was not driven by us, but by somebody else.
Fair enough. So let's do another round. 1, remember your numbers. Sarah, you're 2. Do people change their minds? Sarah, yes.
Okay, I've got a little bit of confusion about an Article 5 convention, because when we first talked about it in Houston, we immediately lost somebody in the group because we were even talking about it, because he said we were opening Pandora's box with an Article 5 convention, anything could be discussed. And then since then, I have talked, we're working with Wolfpack in Texas, and I've talked to Todd Jagger, the Wolfpack person there. And Todd and other people have said no, in an Article 5 convention, the only thing that may be discussed is that particular issue which has been brought up for an amendment. So my question is, and then David, you seem to have gone back to the opening Pandora's box thing, so what's the deal? I don't, with the Article 5 convention. What is the
Would you
reality
ever,
there?
since these delegates are elected, would you ever elect a senator to only discuss one issue?
Yeah.
That's not the way it works.
Well, I was told that there was a rule that was the way it worked.
And Congress may stipulate some instructions to a convention.
Okay.
Supposedly, they're only supposed to pick the location and time.
Okay.
But people believe that Congress may specify that they're only supposed to talk about a certain amendment. Well, what does it mean? You can't get Congress, it will become a temporary fourth branch of government. These are elected positions. The Congress might stipulate these things, but this is an autonomous convention. And yeah, they can talk about whatever they want. Congress might get real upset about that. They might even want to call in the Army to try to bust it out. But the convention also has the right to defend itself with a sergeant of arms. It's an institution that is supposed to be there. It's supposed to be there. It's supposed to have been there a long time. But you would not elect a senator to only discuss one issue. And that's basically what you're doing, is you're taking away the right to debate and propose amendments from the delegates that are elected to do exactly that.
If you were to say, I'm sorry?
The Congress can specify, but they don't have any teeth. There's no way to enforce it.
Okay, David, what's your opinion?
Well, I mean, again, like, it's not clear to me which one it is, and we'll do another one. There are constitutional scholars who say you can specify. There are others who say no. Once you reach the threshold, when a convention is formed, everything is on the table. Like,
Congress
So
can
the bottom
pass a
line is
law.
we really don't know.
Congress can pass a law saying all rainbows should be purple.
Okay,
Does
well, I
that
guess
make all
that's what
rainbows purple?
my point is that if we really don't know, that's really an important point to clarify in this, is that we really don't know.
Well, again, like these procedural questions, all they end up doing, in my experience, is people get like wrapped up, hung up, and then people even actually leave over things that are actually mostly premature. Like, so I'll answer the question to the best of my ability, but that's also back to why Move to Amend at the National Leadership Team and said, let's build a multiracial movement for democracy, and like recognize that we're like, I've got, at Move to Amend in my head and in your National Leadership Team, we've got steps A, B, C, and D down pat, what we're gonna do. We've got E, F, G, and H. We feel like we've got, how are we gonna, J, K, L, maybe? But honestly, there's all kinds of murky stuff. X, Y, Z, peace, just democracy, and ecology with civil liberties for all. We got that part. So you know what I say? Like, it's not like we're just sort of muddling along, but we're also sort of trusting the process of the people, having confidence and faith in ourselves and in you and in each other, in our ability to build a movement. And so your person who left a group over, even bringing it up, I mean, again, I don't know even what to say about that.
Neither did I at the time.
He brought up the Defense of Marriage Act earlier. That God forbid, they're going to get together and they're going to pass the Defense of Marriage Act. First of all, it takes 66% to pass in a convention, just like in the House or the Senate. But Congress already passed DOMA, and it failed in the states. That's exactly what I was saying. You have to have the consent of both sides, or it's going to fail. They could not get it ratified.
There was not a constitutional.
No
It
constitutional
was an
amendment.
act, the A's failed for an act.
Yeah, I think
Federal
you've got it.
Okay.
It's okay. The Defense of Marriage Act was a legislative enactment. It wasn't a.
They were the one from state to state, though. The Oregon
Maybe.
voted it down.
We'll flag that for folks who are interested in it. Number 2, and then because we'll do another stack. Ahead of 2. Yes.
Just a clarifying question. So there is two schools of thought by constitutional theorists, and some believe, from what I'm hearing, that for the applications, they all need to call for a specific reason, and other theorists believe that they just need to, in general, call for a convention, and that those count the same.
Let me try this, because I think that you've actually merged two different kind of things. There are levels of complexity to it. There is, can you limit what a convention discusses, as one question, and you say no, others say yes. There is the other thing about whether you even trigger a convention, whether it has to be just general, whether it calls for a specific thing, and how you count them. So there's multiple things at stake, as I hear your clarifying
Yeah,
question.
I'm mainly asking about like the application. So like there's also two schools of thought on the applications. Like some people think they like just haven't really decided, like no one's really taken the time to like figure out how we're gonna count these. And then so there's still like basically two schools of thought, like no one's really decided like when we'll trigger it.
Yeah. Well, definitely, some folks over at Goldwater Institute definitely feel like it has to be same subject. Lawrence Lessig believes they all add together. I believe they all add together. And again, I believe that it just boils down to the application itself is asking for a convention. The Congress doesn't have any right really to tell the delegates what to propose in the convention. The amendment is a suggestion to the delegate in the application. It has no legal effect.
We'll do another. All right, so did I clear that stack? So I saw two hands that we haven't, so I'm going to go 1, 2, 3. If you haven't made a Margaret, you'll be 4. Larry, you'll be 5. Lee, you'll be 6. Any others? Then 7 and 8, and Mark, you are 9. So we've got 30 minutes left, so a lively discussion. Aren't you glad we're not actually going to make a decision now? Number 1.
This should be easy for you. I'm not steeped in this. I'm listening to it really mostly for the first time. Tell me why I shouldn't be worried about something that I'm now very worried about when I listen to this, which is, let's say method number 1 is Congress and number 2 is the convention. I'm worried that all of this critical mass of people wanting to change the Constitution for the very focused reasons that I'm behind and move to amend, that all of that would be possibly frittered away and disenfranchised if we don't even know the rules of number 2, and if it gets there and you're right and many amendments can be proposed and there's bedlam. I just think that it would be a pity if what I'm worried about has any validity. Talk me out of it.
Well, I totally understand where you're coming from, and that is why you not only have a duty to vote, you have a duty to run as a delegate. You have an amendment that you are already advocating for. You believe in it strongly. Express that to your community. Get in the convention. Propose it. Vote on it. This is not for the elite. This is for garbage men. This is for the common people. It's not a group of politicians. You know, if you look around, also historically, I'm not basing this on blind faith. We've had hundreds of state conventions in this country. State con-cons are normal. Not one of them has jumped the tracks. You take a look around the world.
What was it?
Not
one of them's been a runaway convention that's been the absolute nightmare disaster that everybody...
There's only been one national runaway convention, actually. 1787.
But if you look around the world, for all of the rhetoric that the John Birch Society or the Eagle Forum will put out against the convention, they cannot point to a single convention in this country or any other and say that is the case in point why we should never, ever do this. This is all smoke and mirrors. This is not what we should be afraid of. This is not their machine against us. This is our tool to reform them. And I think that we are obligated. The last state convention in Hawaii had 107 delegates. Only 9 of them were actually politicians.
Here, here.
So we're gonna need to be short with our answers because we've got a big stack. So I want to speak to you very directly as a move to amend person on the national leadership team and tell you why I don't think that you should actually, I think you should be concerned, but that it's the reason to focus our efforts. And that is to recognize, as Ryan did, that this notion of sort of dual tracks has actually been used successfully before, right? So this is the thing, we shouldn't be afraid of the power that is inherent. There are 2 methods. We should be building a movement and be looking for opportunities where they come up. Now, Move to Men will actually fight over language, regardless of these 2, because we exist for a reason, right? But we're not going to try to stop either one of these. And so if there is movement, again, Nolan, what's up with Minnesota? Minnesota Representative Nolan came to us for the amendment. We weren't even going to go to Congress. Like Mark is talking about how using the state legislative process was sort of imposed because they had an elected official who was like an actual people's representative that kind of pushed. That's what happened to us too. And again, Duluth. We got John Marty, Nolan, what's in the there really is something kind of unique about the Great Lakes, right? But here's the thing, y'all. At the end of the day, I think that we're just getting started. And the fact that this kind of conversation, we should embrace it, right? Because it actually is showing that there is an awakening power. So that's how I look at this, and I find it actually exciting. Frustrating at times, but, that's part of life, right? Number 2. Yes?
Correct me if I heard you incorrectly. You said that Lawrence Lessig said that if you do a constitutional convention, it opens it up to everything?
He said that all the applications add together. It doesn't mean which topic, which subject.
At least the last time I read what he said. I'm not arguing with you, I've tried to figure it out too. Was that if the states ask for a constitutional convention specifying the topic, then you can. Or is that not?
Does it add together? We don't know what counts. We don't really. Nothing counts. Nothing has been counted. We have no standard by which to go, oh, this is what they count. But the truth is, if you go back to 1789, you look at the first two applications that were made. They were made for general conventions by the state of New York and Virginia. And the reason was they didn't have a Bill of Rights yet. So they wanted to talk about all kinds of things. But the reason that they kind of left that in there too was that they expected that slavery would be abolished someday as well. I don't think they had any intention of limiting this group. They certainly didn't limit their own group at all. They were supposed to work out an interstate trade agreement and then to forming a new nation. So when they get there, it's hard to say what's going to happen. Trying to imagine this is like trying to imagine what Atlantis looked like. Nobody knows. But the truth is, again, if we have 13 states that can defeat any bad idea that we don't like, then really it only takes 13 state senators to filibuster any bad idea. Bad ideas are easy to get rid of. It's trying to get the good ones through. And what we're trying to do is provide the opportunity for these things to get proposed and considered by states. That's it.
Number 3.
That's me.
Go ahead, please.
So this reminds me a little bit, I get some talks about Move to Amend, and it always comes up where people say, well, once the amendment passes, will corporations be able to do this? Will corporations be able to do that? What exactly will happen? And my answer always is, we don't know. There will be an amendment to the Constitution, and then there will be new litigation and new court cases that will interpret it and decide the specifics. And we just have to have faith that once the amendment is in place, setting the groundwork and the basic rules, that the situation all these learned opinions about what the rules are exactly that, learned opinions. There are no rules, and the rules will be made when it happens. So to me, that just underscores that we don't know. You know, that if we were, you know, we're about the amendment, we're not about how it happens yet. I think that I agree with David. This is a really good conversation, and let's just not get our, as my sister would say, don't get your panties in a bunch.
I think that's why we complement each other so
You
well
know,
here
it's
too.
a really interesting conversation, but it's just a conversation.
Okay, we got 15 minutes left. Number 4. My trick only works if y'all collectively remember your numbers.
All right, I'm Ryan from Wolfpack, so there's a few things that came up. We actually actively promote the convention option. So I just wanted to address what you said in Texas and your concerns, because I think it's valid to have concerns, and there's some education that needs to take place. First thing I want to ask is, do you believe in democracy? Believe in democracy? Okay, I
That's
do
a
too.
trick question.
The reason I'm pro-convention is because I believe it's a democratic process. I believe that when people get together from a diversity of perspectives and they deliberate and they find solutions together, I think it's not only going to be a better amendment, I think it's also going to be more likely to be ratified. And so that's why I actually support the convention, despite the fears that the John Birch Society has pitted for the last 30 or 40 years about this process. The next thing I'd say is we know it can be limited. Here's why. There are 700 applications, right? And if they all counted together, you could take 10 here, 10 here, 14 there, then we'd already have a convention. Now, it may be the case we're already going to have a convention, and Dan Marks will be a hero in history books if that's the case, right? And I hope we'll all be in the convention to get this amendment put in the Constitution, right? But if those 700 all counted together at this point, we'd already have one. Now, what we know is from the 17th Amendment, they got within about 1 or 2 states, and Congress was like, okay, you can have your amendment, right? And that's happened 3 other times, too. So even if at the end of the day, what we're doing, organizing for the convention process, gets the amendment through Congress with you, we're at the victory celebration, too, going like, you guys are geniuses, we love you, you know? And then, you know, the 34 resolutions could be open convention calls. There are 4 outstanding, I think, Mark, Dan, right?
I believe there's 32
For a general convention.
for a general convention.
Right, so you can call for an open convention. We want it to be amended. Now, that doesn't mean you can change the Constitution, right? That means you can amend the Constitution. And those are specifically open calls. But most of the other calls are actually for a limited purpose. And what the Congressional Research Service said in summer of I think July of 2012, they said it has to be a limited purpose and has to call for a convention. And we've seen that validated by the actions of Congress in the past. What I know is from Sam, who's our legal guy. He says there's like de facto and there's de jure law, right? Is anybody a lawyer? You guys are lawyers, right? And there's law by decree, by fiat, right? And so what these resolutions represent is a decree from the states upon Congress that the convention will deal with this purpose. And what I want to say is, I want to use the convention process to fix other things too, right? What about a second Bill of Rights, right? What about a war referendum amendment? Think of what we can do when we give the people the power to amend the Constitution, right? So this is just the first convention. Let's keep it limited to this purpose. Let's fix this problem first. And once we do that, like Lawrence Lessig said, this isn't even the most important problem. We're boiling the earth right now. But it is the first problem that we have to solve before we solve the rest. And whether or not we get it through a convention, or we get it through the states, or we get it through Congress, God bless. I just want this amendment. Thanks.
Number 5.
That's me, and, well, I realize I had to be late, and so if you already discussed this, ignore it. Is there any sense of what the actual process would be for identifying who got to go to the convention?
We can do it super quick.
Election, it's just like Congress. It's the same definition
And
of
there would be
federal
like,
election law.
there would be the same numbers from every state?
That is ambiguous.
Because it's
There
not
was
in
a
the
report
state.
recently
It's not
that
in the
I mentioned.
No, it's not in the Constitution.
No, it's not.
Where can we find out?
So on the list of unknowns.
You know, actually, it is, but I just heard Carrie ask, where can you find out about this? I got to say, articlev.org is a great place to go, where it sort of lays out, well, here's the research, here's what people are saying. I mean, they do a good job of being a clearinghouse for these kinds of questions. So, and it is ambiguous, like.
It is, and you know that, it really, the report that came out last year from the Congressional Research Service on the Article 5 convention process is really the Bible for our group. It is stance on a lot of these positions, and it does note that is ambiguous. There isn't a set process for that. However, I recently found that it is covered under federal election law. Apparently they amended it in 2006 and included it in the definition of election, and apparently all of the election law applies to it. How it applies to it, I don't know. It's really got me scratching my head too, to tell you the truth, because I'm not sure. I mean, that's kind of one of the next things I want to do is kind of grill the FEC on what are you planning on doing here? Because you've already got it codified somehow. What are you going to do? So
The electoral college is a good example. It's a
Number,
delegate.
folks, we can do this if we stay disciplined. You were 5, Mary?
Yes.
Number 6?
Yeah, I originally raised my hand because you said, I really support the dual track idea, but also the idea that we have to build a movement first and not divide ourselves. But I was thinking that if we built a movement for a particular amendment as the first one, and we have the power, I would in fact have people run on one amendment and elect them that way. I mean, that's the whole point of us building powerful enough movements. You're saying you wouldn't elect a senator. I would elect someone to a convention to do the job I wanted them to do. That's just one point. And the only reason I care, I like the thread idea. I like using the Article 5 convention now as you know, a leverage, and maybe we'll get there and let's not worry about it, but let's work together. But I do think we need to be able to, therefore, to defend the possibility of such a convention to our legislators, because that's the problem that they ran into in Minnesota. And I want to throw in there something Lawrence Lessig. If you don't know who he is, he's a Harvard law professor, and he's just like he's the best message guy, probably besides David, that I've ever seen. But anyway, he did this amazing thing with the state legislators. You were there. He said, we have some, these were just run-of-the-mill, judiciary committee legislators, but he gave them this speech where he said, when the founders, and everybody gets all their heart pounding, when the founders were thinking about this, they realized if we're going to amend the Constitution and Congress is the problem, then what? And what they decided was that you, the state legislators, have the power to save democracy or something like that if Congress is the problem. And I just saw them puff up like little peacocks. We got, every legislators really want to be here. That's the first time they started listening. They were like, oh, the founders wanted us to save democracy. So anyway, that's a really good rhetorical thing. I know there's a lot of worries and stuff, but I just wanted to throw that out there. It was very effective.
Sir, I see you're trying to raise your hand. We've only got 9 minutes. We already have a stack, and you just walked in. If you want to come and talk to us afterwards, that's fine, but we're not taking any more. Number 7.
Yes, Don, I'm thinking about your dilemma of how do you get them to count.
mm-hmm. Yeah.
Have you thought about filing a petition for a writ of mandamus?
We have.
Mandating the appropriate congressional officials to come up with the rules for how to count.
We have thought about that. We haven't done it yet. Right now, they offered to pass on this request to the Judiciary Committee. I also talked to Tom Wickham, the House Parliamentarian, and he's basically the traffic cop in Congress, and he was the one who actually established, you need to deliver this to them, write it exactly like this, and so we were trying to get this to work from inside Congress. The writ of mandamus, we're even trying to figure out what is the court of jurisdiction on that. Is that the Supreme Court? Would it be the state courts of all the different states? It's kind of confusing to us.
I think it would be D.C. District Court first.
District Court first. Okay.
I would think, but
yeah, I mean this is all uncharted territory, and the writ of mandamus was probably closest to the best way to enforce this, but then when I get this letter with an admission that they have neglected to count these things
That's a
for
good-
200 odd years, I think it's time to call the president and see what works.
But
That's
that-
evidence in your mandamus hearing.
No, but that's exactly, that's great evidence to present to the
Right.
district court judge and say, hey, look, they've admitted they've neglected their duties.
It would definitely be district court in DC, right? Because that's where the
Exactly.
rhythm comes. So if you're gonna do that, that's where to do it. What number were you, Steve?
7.
Number 8.
I'll take it on 9 if there's no 8.
No, I'm not.
What?
So you are 8, Mark, go.
You're eight,
I'm
go.
going for it. So,
Nine,
in
eight.
Minnesota, we need to sharpen our talking points to rebut some of the pushback on the Constitutional Convention. Right now, the one example that we use in terms of where a threat of Constitutional Convention forced Congress to act is the 17th Amendment. That happens to be about 100 years old. So this is a question for both of you guys. David, if I'm correct, I think at one point I had heard you say that during the efforts to lower the voting age from 21 to 18, that the threat of Constitutional Convention forced Congress to, the threat of Constitutional Convention forced Congress to pass a constitutional amendment. I haven't been able to find anything out about that. So number one, is that true? And number two, can you give me some documentation for that?
Do you have it on your website?
We do have all of the known applications on record from the congressional report, and it's listed on our website at articleb.org/map. Voting age, I'm not sure how many. To tell you the truth, though, I don't think there were that many. There were all kinds of proposals during the 1960s, but I don't recall too many that required voting age. The other thing that you mentioned there was the 17th Amendment, that we fell one state short. That's not true. We actually passed it by several states. Even the state of Wisconsin, in one of their applications, counted up, I believe it was 37 states. They named them in the application, and they cited Article 5 in the application and explained to Congress, what's the problem? You know, it's, it was amazing.
Let me do a follow-up. What's the most recent example we can use? 100 years ago is a little old.
For what a constitutional convention.
Where the threat of constitutional convention forced Congress to act.
Does anybody know the answer? I mean,
I'm working on it.
okay, so we'll come back. Thank you, Ryan.
The
And the
Bell's
technology.
Amendment in the 1980s also passed the 34 state threshold. They didn't pass
But he's
that.
saying it was successfully used as a threat that resulted in the constitutional amendment. I think that's the question, right?
I think, along with possibly a threat of a convention, was the tenor of the country at that time.
Right, and so this is the thing, Mark, I think that I'm going to stand on the lowering of the voting age, and I haven't done the research on it, but I kind of have this thing that there was this, I do remember that there were, that are looking at, I mean, I wasn't like politically active, but that there was, you can vote, or you can die for your country, but you can't vote. And it became a political, like, moment that was such that, and I believe that the, whether or not there were formal applications to the state that actually resulted in votes going through, but I think that there was political effort making it happen. Can you give us some information, Ryan?
Yeah, the information I have from some of our volunteers, who are very good researchers, say that the ones that have pushed for a convention were 17, 21, 22, and 25. Only after many state legislators had called for an Article 5 convention on each of these issues. So those are the four, at least according to this research, that used the convention track and then got the amendment from Congress.
So number 9.
Just clarifying that, I guess it's become real clear that the Constitution provides for the states petitioning the Congress for a convention, but it doesn't require the Congress to respond to that request.
No, it is a peremptory call. It says Congress shall call a convention upon the application of 2/3 of the states.
On the application of 2/3, it's a, yeah.
Go ahead and
Well,
crash out.
okay, and the final thing I would like to say is, you know, when I start hearing about fear, the only thing I can think of that you gotta use to get through it is courage.
Exactly.
Yes. Yeah, we haven't heard from you, Mary Beth, so please be brief though, because we're at time.
So it seems like the problem is there's no rules. And it's not in the interest of Congress to come up with rules.
Right.
So why not take the power to ourselves to make the rules and create something like a process to develop a public framework that would have the answers to these questions ironed out, protections from corporate and political influence. Couldn't we use that, in fact, as a further means of organizing and engaging people, and it would be like the kind of encampment event that Occupy was, but maybe with a more traditional format and shape. And if we did that, what would it take for the public and the government to take this seriously? If we took it seriously, wouldn't that be enough?
So again, I'm going to give you 1 minute to answer it and make it your final comment because we're at time.
One of my friends will love that you asked that question. He came up with a concept that he called the National General Assembly. And he was trying to go from state to state and get other state legislatures to adopt this and push this and try to get the federal government to adopt it as well. And it would basically establish the rules, fill in the missing gaps, and make it much easier for everybody to do this. But how to I mean, it's tough to figure out which branch to even start this kind of entity in.
I don't think you can ask for permission. I think you have to do it around the country, hold several of them. And if we take it seriously, and we come up with a framework that most Americans can agree with, don't they have to agree that it's better than not having anything?
Well, I mean, certainly if your choice is A or B, my choice was B, clearly. The rules, I definitely think would help put people at ease. And I would love it, actually, if we could do something like that. I don't see why we can't take a look at adopting new rules. There's other people in my group, Bill Walker, who used to be with the Friends of Article 5 Convention, who was also the guy that sued the Congress. He says that basically all those gray areas are answered, and he's usually got an answer for everything. So we'll find out, I guess.
Okay, so thank you. In 1 minute, I want to do this. If by some miracle you have not yet gotten on track with Move to Amend, come on up and let's get you plugged in. And in my last minute, I talk all the time about how quickly we've grown, and it's definitely true, and it's because of people like you. But, we've talked about the Minnesota model multiple times. I just feel obliged at this point to just take a moment because we only got started at Move to Amend in 2010. Well, in 2010, I got a phone call from this crazy person. I wasn't sure if they were crazy, but they had a crazy idea to actually walk across the country on behalf of Move to Amend. He was crazy enough that he thought he'd get his brother involved. So some of you already know this story. There are also 2 Minnesota boys. And so in that spirit, I just want to use the last seconds of this to actually have Robin Monahan and Laird Monahan to stand up and take a round of applause. Going forward. Not too unpopular, they're real approachable. Thanks so much. Thank you. Landmarks Article 5. Peace. And really, if somehow you're not getting Move to Amend stuff.
Terry.
Anybody wants something? I'm going to be here for a while.
Oh, yes, thank you.